Wonderful. It is now 5 minutes past. Welcome, everyone. Right. My name is Sibongile Ndashe. I am the Executive Director of the Initiative for Strategic Litigation in Africa, one of the organizers of the ACHPR civil society side events. ISLA Conversation is an annual conversation that I have with someone who is an expert on a particular issue. We started this conversation in 2016. We've had Professor Rashida Manju, the former UN Special Rapporteur on Violence Against Women, Nicolette Naylor from the Ford Foundation, Regional Director, Southern Africa, Advocacy Penzi Tlakula, former Chairperson of the African Commission on Human and People's Rights, and Dr. Ruth Nekura, last year, who is an expert on violence against women. Today's conversation is posed as a rhetorical question on whether it is time to advance SOGIE, sexual orientation, gender identity and expression, using litigation before international and regional mechanisms, and the African Commission in particular. It does sound like a rhetorical question because the question should be able to provide a straightforward yes answer. But during the course of this conversation, you will understand some of the complexities that makes it necessary to ask this question as we begin to find out what the journey would look like, if at all it is possible to embark on that journey at the moment. International travel may be closed to some of us, but with this conversation, we hope to travel and look at what's been happening in Geneva, the UN, before the various mechanisms, and also to be able to look comparatively at what's been happening in the inter-American human rights systems. To help me have this conversation, we have the pleasure of being joined by Victor Madrigal-Borlos. He is an independent expert on protection against violence and discrimination based on sexual orientation and gender identity. In this capacity, he assesses the implementation of international human rights law, raises awareness, engages in dialogue with all relevant stakeholders, and provides advisory services, technical assistance, capacity building, to help address violence and discrimination against persons on the basis of sexual orientation and gender identity. So we haven't really taken him out of his way. This is very much out of his mandate. He is a Costa Rican jurist. He has served in various bodies, in the International Rehabilitation Council for Torture Victims, was a rapporteur on reprisals, and has worked with a number of other organizations, including Danish Institute for Human Rights and the Inter-American Court of Human Rights. So Victor, very welcome, and we are very happy to have you with us today.
Thank you very much, Sibongile. I'm delighted to be having this conversation across time zones, as technology allows us to do these days. The reality is that I have to share with all of you that on one side, it makes me happy to see you on the screen, because that makes me know that you are well and that you're doing fine and that you're persisting in your work and in all of our struggles. On the other hand, I miss the possibility to being together. I miss the energy that comes from togetherness, and I do hope that at some point in the future, this will be something that a conversation that we are able to have together in front of a cup of coffee. For the time being, we actually use the less intimate but available means of the internet, and I'm delighted to join you across time zones from Washington, DC to have this conversation. Now, I think that these conversations where we come together to share knowledge and build global joint voices are fundamentally important in relation to these issues. And they are also fundamentally important, Sibongile, in the construction of the agendas for my mandate. So I am absolutely delighted to be with you and very much looking forward to the conversation.
Okay. Thank you very much. We all live in hope that one day we will be able to meet, and hopefully it is very soon. So in this traveling, this conversation, we are going to have a conversation that we break into 4 parts, actually. We want to be able to answer the role that have been played by international and regional human rights mechanisms in advancing SOGIE. And here it's really us having a conversation about the landmark cases. And from there, we will continue to look at the standard setting work that either laid the foundation for litigation to happen or that has been built on top of the litigation work. So it has happened in various ways, but what's the norm elaboration work that has happened and how it has come about in these various stages? I mean, we are having this conversation very much as a comparative because we want to be able to learn and understand, and we are looking at what's happened in the inter-American system and also what's happened in the UN system. Then I think this is, one of the hardest conversations that most of us, here we kind of understand the rights kind of framework and discourse, but what makes it so hard to move beyond the rights language, that if the violations are quite clear, what are all of these things that are kind of holding us back and making it harder and harder, to make progress in certain spaces. And then finally, I think we want to be able to close on a very positive note, which is about how do we kind of move forward from here? Like, what does preparedness for this work look like? What are the things that we can imagine as being the kind of basis if we are going to be able to build incrementally? So without further ado, Victor, I think I'll just start with you about how the UN kind of human rights systems have been able to navigate, developing jurisprudence on SOGIE over the past number of decades since it started hearing these cases.
Thank you very much, Sibongile. I'm just looking at you to make sure that you can hear me right.
Can you?
You can see me right. Okay, thank you. Let me start by prefacing with an assumption that if there is anybody who's academically inclined within our audience today, I think it would be quite fascinating to take forward. I assume that lesbian and gay and bisexual and trans and gender diverse persons have always been present in the work of the United Nations since day one, because of course, LGTB persons are present in the social fabric and in our lived realities every day since day one. So one of the assumptions that I have is that implicit in a number of the developments in international jurisprudence from the beginning of the work of the human rights machinery, there are a number of cases in which real reasoning at the origin of violence and discrimination was sexual orientation and gender identity. And I assume that what we know as the beginning, the formal beginning of this work, is more the formal acceptance that sexual orientation and gender identity would become acknowledged and accepted as protected grounds from discrimination and violence under international human rights law. And I think that this is a substantial point to make, because I don't believe that it would serve any purpose to anybody to actually think that violence and discrimination started in 1984, the year in which the UN Human Rights Committee knew the case of Mr. Tuin. I believe that treaty bodies and special procedures started the protection around sexual orientation with work on criminalization. With this case, with this first explicit case, and Sibongile, with a firm grounding on a reasoning which was based on the idea of privacy. I think that Tuin, this 1984 case, very much related to the HIV/AIDS pandemic and to discrimination related to aspects somehow germane to the HIV/AIDS pandemic, is of course the case in which the UN Human Rights Committee ruled that sexual discrimination is a protected category under applicable anti-discrimination principles. And the reason why I want to signal that there was such a strong angle in relation to privacy in the Tuin case is because, although admirable as a step in acknowledging that sexual orientation and gender identity are part of the prisms through which violence and discrimination must be interpreted, it did signal a trend that was going to continue for, I believe, decades, in the sense that this rationale that LGBT persons were protected from violence and discrimination, but that there was the subtle messaging that this was dependent, infringent, somehow connected to the idea that they should maintain their identities as existing in the privacy of their bedrooms. I think that this approach created some struggles in the Cairo and Beijing World Conferences. We all know that Beverly Dizzi-Palesa, the great admired statement that she made to remove the brackets around sexual orientation in the draft declaration and platform of action in Beijing. And to me, this tension between understanding that acknowledging sexual orientation and gender identity, not only as elements that protect privacy in such, but most importantly, as elements that have to be acknowledged as originating a right to occupy public space with our identities, with our orientations, is something that was not necessarily very clear in Tuin, and I think it has created a difference in trend that has percolated through the international jurisprudence over the last 30 years. Now, this is because, as you know, Sibongile, scholars from the Global South, at least one put it to me in this way, and I'm quoting her, in order to fight violence, women's rights groups has historically demanding that the states come into the bedroom, and to achieve the same objective, gay rights groups have historically demanded that it stay out. And so I think that this is part of the very strong tensions that have existed in the last 30 years in the development of this jurisprudence. Now, Ms. Palesa's powerful call was, in fact, in my view, a call for a stronger framing within the theory of discrimination. And this has been the path followed in the global arena, I think, for the last 30 years. We find an announcement of it in the ill-fated Brazilian resolution of 2003, and with the very, very significant milestones in Human Rights Council Resolution 1719, presented by South Africa, in which expressed concern about violence and discrimination on the basis of SOGIE. This resolution was the one preparing the ground for the two excellent reports by the High Commissioner for Human Rights in 2011 and 2015. And the reinforcement of this work has been also present in a plethora of statements by United Nations mandate holders and treaty bodies. Now let's take into account one aspect of this. This body of doctrine and jurisprudence is robust enough so that it could give rise to a systematization under the Yogyakarta principles, a significant systematization, which is based not in new formulation of international law, but on a way to organize the information actually issued by United Nations treaty bodies, special procedures, the Office of the High Commissioner, and more recently, the UPR. So all of the pillars of the human rights machinery at the United Nations. And I think, Sibongile, to conclude on this aspect, that the creation of my mandate signals a third stage in the work of sexual orientation and gender identity within the UN. Indeed, the mandate has a frame conducive to satisfying a call made by many scholars to link in a much stronger, more integral and coherent way to other constructs and to other concerns. The reality of the matter is that the creation of the mandate, very controversial, but still effectuated, and its renewal in 2019, less controversial, which demonstrates change as well, signify, in my view, the explicit acknowledgement that sexual orientation and gender identity are necessary prisms to deconstruct, analyze, systematize, and address violence and discrimination. And this is very far from being a minor development under international human rights law. I think that the work of the UN is marked by these different stages. What is coming into the future is very much the understanding that these seeds that have been planted throughout the system must now be actually taken forward in the form of new standard setting, new policy making mechanisms. We all know, for example, that the Office of the High Commissioner has developed a strong plan of work that includes the Free and Equal campaign, developed in many countries around the world, and the standards for business conduction that is free from violence and discrimination against LGTB persons. There is significant work as well by the Office of the High Commissioner in nurturing the dialogue between UN bodies, the African Commission, and the Inter-American Commission. And this is why, Sibongile, this conversation is a particular opportunity and a privilege for me to participate in, because I think it is a continuity in a way to this work of ensuring that global developments also nurture from developments at the regional bodies. Very much, of course, also those dependent and derived from international and regional litigation.
Okay. Right, thanks. So just to pick up, I think, on some of the issues that you raise, like the issue of privacy, I think one of the things that's very clear around the development of either national jurisprudence or regional jurisprudence on the right to privacy. The right to privacy remains one of the least understood and also kind of grossly underutilized right in the African human rights system. So where jurisprudence, I think, in other contexts on privacy has really looked at privacy in the context of private life. Privacy has for many ways kind of been located even under fair trial, kind of, privacy in a criminal, justice process, that people need to have a search warrant, to be able to do that. So it's like privacy of the home, not privacy of the person. So part of it, it's really a significant mind shift that would need to happen around what it is that would be required, I think, on the continent, the kind of rights or the issues that one would need to be able to identify as being the kind of cases that people start with when one wants to be able to go to court and litigate and develop jurisprudence.
Right.
But in many kind of conversations like this, I think one of the things that come up is what's the strategy for the first case? What are the kind of cases that people go to court with? And in the UN context, you talk about Tuin, as being one of those cases. And of course, what is important about Tuin, it's also that it was located within a very specific context, in terms of political moments, around HIV. And so even in the understanding of that issue about what it means to actually have laws that criminalize same-sex sex. But what I found interesting when kind of looking comparatively at the inter-American human rights system, it's the kind of cases that have been before the commission and later referred to the court, or even the advisory opinions, right? That these aren't the so-called obvious cases, you know, that one normally starts a conversation or open a conversation with, which really speaks to, one, it's something that we can get to later about how we organize ourselves as lawyers, as civil society, when we think about what it actually means to begin engaging the mechanisms, especially in a context when there hasn't been, you know, a case before. In the African human rights system, there was a case that was filed and withdrawn, and it was a case against Zimbabwe, which was seeking to challenge criminalization of same-sex sex, but that was a very, very long time ago. And since then, there really hasn't been an issue. What has been happening is this kind of contestation around the mechanism's mandate to even do standard setting work or norm elaboration on issues related to SOGIE. But what we are seeing, so one looks at cases like Giraldo, so in line with this kind of analysis and understanding of a strategy for the first case, which normally includes issues that states themselves don't feel that they have solutions to. So when the mechanisms take a decision, they are not actually doing stuff that's going to be alienating them, you know, from member states. It's like, we are here, we are enforcing human rights, but we are also helping you to do stuff. And in our context, for example, when one looks at the African court, which is actually not a very old court, you know, so, and what we have seen over the past few years, a number of states actually withdrawing, you know, they are concerned, you know, to be held accountable before that court, you know, their declaration that allows individuals and civil society to actually go there. So we are dealing with mechanisms that are actually very weak, you know, by themselves. And because, as we all know, they are as weak and strong, or strong as the people who establish them, you know, want them to be. So there is that kind of fear, right, around, okay, so what are the kind of cases that would make sense to actually take there, but also whether the mechanisms, when they have taken these decisions, they will be able to deal with the wrath, you know, of member states by having done that. So it's quite interesting, though, that one of the things that the UN started in the norm elaboration on the 2011 resolution that you responded to, because the origins of that resolutions were not very pretty, you know. So when one looks at the first draft, I think, of the resolution, which was presented by South Africa, having been acted on by Egypt to go forward, utilizes a trick that Egypt has perfected in the African human rights system, which is about distortion of international law. So this kind of single modality that they were pushing for, you know, to say, oh, this idea that SOGIE is not a ground of discrimination, but it's actually a new international human rights norm. So this idea that there is this attempt to introduce new norms via backdoor, and therefore this does not follow the process of how customary international law is developed, and therefore all mechanisms of the United Nations needed, you know, to stop. Whoever it was who was seized with SOGIE needed to stop so that the single modality would look at it while a decision is being made, you know? So it's a very sophisticated argument. If you don't, even if you understand international law, like, it seems kind of appealing. So I guess where I'm going with this, it's that even though we had the resolution at the United Nations, at the African Commission, we adopted a similar kind of resolution shortly afterwards in 2014, where we thought, you know, as part of the thing is that, of course, internationally, this was very contested, but it would make the process much easier in terms of kind of implementation of the work if we were saying this is not a UN document, but this is
Mhm.
a regional document that has been adopted by the African Commission, and therefore also an easy kind of conversation starter to say this conversation, it makes sense to start with on violence and discrimination, because when one talks about violence, I mean, there are kind of very few people, well, there's quite a few, but many kind of people will not be able to stand there and say, I condone violence, you
Right.
know? And so that's what made SOGIE, like based violence, one of the easiest kind of entry points. And that's why when one kind of looks at the jurisprudence of the inter-American kind of system, one thinks about all the kind of homophobic and transphobic violence that one often reads about, and that it looked like it was much later in the system, you know, when the mechanism began to engage with the issue of SOGIE-based violence.
Right.
In kind of norm elaboration, that is where in the African human rights we started. And of course, in many countries on the continent, the issue of SOGIE-based violence is still not an issue that has been litigated, you know, on a lot. And I do think that this is something that we'll have to talk about, think about who are the people who are able to go, you know, before the mechanisms, you know, what are the kind of rights, but who are the individuals who actually go there as we begin to kind of source the cases. So, I mean, when you look at Giraldo versus Colombia, is one of the first cases, you know, which deals with conjugal visits for same-sex couple. And you look at Atala or Duke, you know, like the kind of issues that they were looking at, issues of custody, issues of benefits and pensions. And then much later on now you have the issues that looks at violence, you know, specifically. So it is very hard to be able to see a trend or a pattern, I think, when one looks at this, that one can actually borrow from, you know, and say, well, when we are looking at the strategies for the first case, this is where we should start.
Right.
Yeah. Okay, so, I mean, I don't know if you have got any views on that, and we can move on to the second thing that we're looking at.
Can I just react? Well, I certainly have certain views, and what you did was extraordinary, because of course you have now pretty much laid an overview of all of the issues, both political but also intimate to organizations that are involved in taking these choices. And the work of strategic litigation is a work that is, to me, significantly delicate, because I understand, Sibongile, and I wanted to bring this to kind of the fold. International justice takes a long time, and it's subject to a number of vicissitudes that are very difficult to manage. So adding to this complex perspective that you were already expressing is the reality that when one seeks to have a strategic litigation initiative, the first thing that, of course, you need to reconcile is the reality that you're serving a victim, a particular person whose rights were violated and who you're seeking reparation for. And you're also doing it in a system where you hope and have studied that the reparations scope allows not only for individual reparation, but also for considerations of non-repetition, which is what strategic impact will create. But the reality is that there's also a dimension of time. You never know whether the commission or the court in which you introduced your case on year one will be the same one and will have the same perspectives in year 10, when your case will be solved finally throughout the system. So the complexity of these decisions throughout strategic litigation are not only ethical in relation to, for example, the interest of the victim, but are also very much left to a series of elements of risk, where sometimes that is an element that you need to bring into the fold. The other thing that I wanted to react very quickly in what you mentioned is, it is true that the strength of mechanisms is fundamentally important when taking those considerations, but also in my experience, and as you know, I've served the Inter-American Commission and the Inter-American Court, as well as now handling individual cases. It is the reality that mechanisms become ready when the case is compel them to do so. So I think that there's a great motivation for understanding that strategic litigation not only pushes states, it also pushes the systems to actually come into grips with certain realities under international law. And I think that that is the enormous merit of the cases that you provided an overview for in the Inter-American system, which is basically having pushed the system to do what it needed to do.
Okay, so thanks for that. So you have touched on this, but maybe if we can go into it a little bit more in kind of detail. The soft law, the kind of norm elaboration work, sometimes there are all of these conversations about whether there are more standards that need to be set, or whether we need to invest in just the implementation of the existing standards.
Yeah.
So what has been, I think, in the UN systems, and also in the OAS, the kind of foundational standard setting work that has happened in that mechanism that has either built on litigation that has happened, or that could be a very strong base for that litigation, to happen. How has that kind of evolved, and whether at all there's any relationship, between the standard setting work that's done by the mechanisms outside of litigation and the litigation work that subsequently happened or that had happened prior?
Well, that's a very interesting question, because of course, because it might very well be that it's a rather organic process where the identification of how existing standards apply to certain situations may give rise to the need of identification of new standards. I don't mean to be cryptic. Allow me to explain what I mean by that. Through an example. I believe that if we are to take the existing body of international and regional human rights law, there is a vigorous source of law that allows us to interpret most of the instances of violence and discrimination against LGBT people around the world. But I also think that that connectivity and the recognition of how those standards apply is not necessarily evident to every situation. I just issued my report on practices of so-called conversion therapy, for example. And in that report, what I endeavored to do is to actually raise the question, it really was a research question, as to whether all practices of conversion therapy could be considered torture or cruel, inhuman, and degrading treatment, or whether they needed to actually cross a certain threshold to be interpreted under that body of law. And what became very evident to me is that it was not as easy to encapsulate or to create a legal theory in relation to the standards related to those aspects of state action or inaction, because practices of conversion therapy are enormously different all around the world. And so the question is, how do you create descriptions and narratives and language that allows you to encapsulate certain practices and then match them with the standards in a way that it becomes intelligible for state authorities to act upon? The conclusion in my report, by the way, is that all forms of conversion therapy are inherently cruel, inhuman, and degrading, but that they're not all necessarily and by themselves forms of torture, that they are suspect of creating conditions conducive to torture. Having said that, then immediately throughout that research, I came to the conclusion that it was necessary to identify new standards for state delivery of depathologization processes in all states. As you know, forms of conversion therapy are in a way remnants of this idea that LGBT people are somehow sick, right? And in the process of depathologizing, which has now been effectuated at the World Health Organization, there is the fact that there is enormous levels of normative at domestic level, which have not been dismantled. And so in that work, there was an identification of new standards of delivery for states in relation to depathologization. And this is, of course, something that wasn't there before because it hadn't been explored from that angle. And I think that this is the way that you can see that process nurturing itself. Now, what is the liability and the risk of this process? Is that LGBT activists and judicial interpreters and state actors that are actually doing their job by implementing may be accused of judicial activism or activism when expressing how the standards evolve. The reality is that the standards have always been there. The reality is that what we are identifying is new ways of delivery of the standard under circumstances that have not been explored from a particular angle. And so I think that this process is actually quite circular in this way. I would also mention that, as you know, the work of the UN includes, for example, this idea of certain principles and standards to which non-state actors can bind themselves. So, for example, the standards on business are a good example of that. And those are indeed built upon very much consensual discussion and conversation. And I think that they are also a process of identification of new normatives.
Okay. Yeah, I think normally when I have this conversation, I always feel ill-matched, you know, because we are moving from a context where we've had to engage, you know, with commissioners who will waive the African Charter, asking, where do you see the rights of the group that you are advocating for, you know, as part of a conversation on just granting mere kind of observer status. So in one way, one can hear what it is that is possible within the international human rights law framework around how norms and standards are developed, and more importantly, how they are applied, you know, in practice. So just to tell a brief history of the kind of practical things that activists have really started, have been doing, I think, since, I think, way back 2006, when the first kind of organized advocacy at the African Commission started. And this was really from civil society organizing side, trying to push the mechanism to be more responsive. And one of the first things was, of course, people went there to explore whether there was a possibility of advancing advocacy, you know, using the regional human rights systems. And immediately it began to look like the system was capable of responding, because people understood what the process of shadow report was, and then began to do shadow reports, shared these with the commissioners, And the commissioner started asking questions, started including language on some of the reports, responding to kind of the state reports. So it looked like in some ways there was language that we were beginning to see, like commissioners asking about anal exams, or also making statements that anal exams constituted torture, cruel, inhuman, and degrading treatment. So this is also happening in a context of where people are thinking, fine, maybe there are issues that we can do. One, as part of trying to help us do the standard setting, is being deliberate about this process of shadow reporting. But also 2 years later, then the activism say, why don't we ask for the bare minimum, like formal recognition of an LGBT organization before the mechanism, which is about freedom of association, which is the most basic form, like a right when one is thinking about engaging as a member of civil society or kind of capturing civic space. And this becomes a battle that rages on for 10 years, to be exact, from 2008 until 2018. And it has not stopped around the contestation of whether an organization that advocates on LGBT issues can actually be an organization that's before the African human rights systems. And this is part of an advocacy strategy that says what is possible here around the issue of freedom of association.
Right.
But the moment the advocacy shifts to violence, the commission gets it, right? So it agrees to a resolution, whilst the issue of observer status is still a background issue. So if you look at the trajectory in 2014, you get the SOGIE-based, the resolution. 2006, the advocacy starts. 2008, the application for observer status is made. 2010, the application is denied. 2014, the resolution is adopted. 2015, the commission grants observer status finally, and 2018, really under serious political threats by member states, it is withdrawn, right? So what we are seeing here is that, and this is a point that I have made, whilst the cases at the court had nothing to do, with SOGIE, most of them have been really around political battles in countries. We have been able to see member states saying that we are going to leave. But what has been kind of challenging really around the African human rights systems is the way in which member states, right? So you have a political body here and you have a human rights body here, like that very clear distinction that is made. And the human rights body that is tasked with the interpretation of the charter gets its decision or pressure from the political body, to say, you are not acting in ways which are consistent with African values. Then you need to reverse your decision, on that basis. So when one thinks about this space as a site for advocacy or as a place where it is possible to develop these standards, this becomes the barrier, because it's like, what is the consequence? We have the resolution and we have been assured that the resolution remains intact, regardless of the subsequent decision to withdraw observer status. But are the commissioners who are there, or even the court itself, right? Or even the committee, like even the issue of comprehensive sexuality education, or to go before the Committee on the Rights and Welfare of the Child, whether they will be able, to do this, whether they will be able to have this kind of conversation and to be able to make a decision about these issues that are not only morally kind of decide, but very politically tricky, because now they know that there are consequences when that decision is taken.
Right.
So, yeah, I think let me just stop there, and then if you have a reaction to that, or we go to the next one.
Let's go to the next one. Although, as you can imagine, I find all of that topic deeply important and deeply fascinating, but also deeply important. But let's go to the next one just to make sure that we're able to cover some of the aspects that you wanted covered, Sibongile.
Good. So as we continue this conversation about standards or just human rights broadly, the human rights violations, when we talk about the violations themselves, are pretty much straightforward. One can see where discrimination happens. We can see it as a privacy issue, or dignity, torture, and all of that. But somehow it has become even more harder to convince diplomats, politicians, courts, that this is a human rights issue. And I think on the continent, the changes over the past 5 years, in some ways, quite important to understand in terms of the colonial kind of legacies. So we are seeing Lusophone Afrique, for example, decriminalizing. We are seeing English-speaking Africa sitting in a particular kind of state. Some of the courts are beginning to be responsive on issues of association. And French-speaking Africa, which does not have a history or legacy of these laws, but somehow decide to sort of come up, with them. There was that kind of very scary thing, I think, that happened with Gabon a few months ago. So it's like, why is Gabon doing this? So in a context when we understand what human rights are and how they are violated, whether by various practices or laws, what continues to make it harder to convince people that this is indeed a human rights issue? Because I think maybe those are some of the things that we should be kind of appealing to, not instead of developing more human rights standards, but in addition to that.
Well, that's a deeply complex question that raises all sorts of worries about how respectful the generality of people are ready to be in relation to their fellow humans. But being humble before the complexity of what you're raising, let me try and advance 3 working theories upon which I've been developing some work. The first one is that politically, in the field of political presence, creating notions of otherness for certain groups or populations has shown to be profitable in the political arena. More and more, we see populist discourse following a textbook strategy of creating the notion that migrants are quote-unquote others, asylum seekers are quote-unquote others, women are quote-unquote others, and certainly that LGBT persons are quote-unquote others. The dynamic is simple, is to create a notion of fear against the penetration of different ways of seeing the world, different ways of perceiving gender relations, different ways of understanding how freedom can detach us from fates that we are determined because of having been born with a certain genital configuration. So I think that what makes it difficult to convince people who are in politics about seeing this and treating it as a matter concerning human rights is that the moment they do that, they lose this possibility for profit. And I think that significant parts across the political spectrum have chosen not to do so because of that. That's the first thing that I think we need to be very clear about. And Sibongile, I know that you and your sisters in Africa are the ones leading the charge in relation to some of these struggles and fights. This is very much about protecting ways of seeing the world in which the male has a particular position and the female has a particular position, and the world is neatly divided between the male and the female. And of course, there's a perfidious asymmetry of power between the male and the female. So at the end of the day, it's deconstructing the theories that allow fighting violence and discrimination on the basis of gender. And this is the second point, for which I think is a huge ideological point. Recognizing that these issues are human rights deprives that argumentation of their main artillery, which is, of course, the idea that gender doesn't exist and gender and sex are exactly the same. So that's the second angle from which I think there are meta discourses that make it very difficult and very challenging to actually have this broad acceptance. The third thing, I think, is simple resistance to the political cost that it will imply to actually make some of these acknowledgements. I think that what you were referring just before about the legal recognition of organizations brings to me very, very clear reminders of my visit to Mozambique, where, as you know, my first recommendation to the government was that they should enact legal recognition of Lambda, the organization that actually carries out LGBT work in Mozambique, and that has not been formally recognized. And one of the interesting things about this is that Lambda exists in a space where it can operate. It can do everything that it needs to do. It has programming, and it even cooperates with the state. But the state does not recognize it legally because there is this notion that that is going to entail a political cost that actors are not ready to take. And I think that is, of course, part of the things that we strategically need to consider, in my case, how to advise, how to seek the spaces to advise, and in the cases of civil society, how to create energy to ensure that the same or larger cost is attached to non-recognition, to homophobic, misogynist, or transphobic discourse, that it should be more costly than actually the contrary.
Yeah, I'll just add a few things to that before we go to the kind of last point, which is more optimistic and forward-looking. That some of these kind of barriers that makes the rights that we are talking about not transferable to other people's understanding of what human rights is about. When one kind of watches the things, developments in the UN, and just looking at the board after people have voted, one of the things that's quite clear is that the issue of SOGIE is a very visible kind of political horse trading at the UN. So it's like a trade-off. We know that there are states that don't like to see development, language in UN kind of documents, or there are others who don't want to see reproductive freedoms, others don't want to see race or migration kind of thing. So the ones who don't want to see SOGIE, whether they are the majority or the minority, what is quite clear is that these are the things that get kind of left on the floor. In the number of kind of SOGIE-related votes, one of the things that becomes very clear, especially when it comes to African member states, it's the lack of consistency. It's people will vote this way and tomorrow they will vote that way, not because of anything that has happened, but because of who has been sent there and who is the diplomat, you know, who's able to do that work. And so the work, it's really not, it's just political horse trading that happens there. So it contributes towards this kind of flip-flopping and lack of clarity around where we are, whether we are moving or whether we are regressing, because these are not necessarily, like, there are countries that are very consistent, but for some people, these are not issues that are taken or decisions that are taken on principle.
It's 14 hours.
But on the continent, I think that the presence of different actors whose motives are unclear, because you speak to the kind of political, like the profit that people have. In many countries, for example, SOGIE was never a political issue. So kind of injecting it in politics, it's something that's very new, and we know where people learned it from. But the different actors, you know, also that operates in various parts of the continent. It's something that some people understand, but I think that we need to understand it very well. You know, so you have the religious kind of fundamentalists from Western Europe and from the US. In Francophone Afrique, it's the role played by Russia in pursuit of its kind of illiberal kind of agenda, but this language that they have used in the UN systems around traditional values. And some of these actors do act together, but part of the strategies, and I think how this work gets exported to the regional human rights system, it's one of the things that I don't think that we have, because at the national level, we have been able to see that they have scaled up when it comes to their tactics, you know, just being able to engage with key politicians, with human rights groups, trade unions, doctors unions, or teachers, teachers professional unions, so that they can push back against comprehensive sexuality education. But for our work, the investment in engaging lawyers groups, whether they group them as family lawyers or whether they group them as Christian lawyers, it's something that we are also seeing as part of this pushback. So they have gotten better at organizing, but the language also has gotten much stronger in the kind of pushback. So these are some of the current challenges, and I think, and threats, that the fault lines when it comes to these fundamentalisms are shifting, but they are, and also strengthening in when it comes to their tactics. And so when they meet member states, you know, so whether it's a religious fundamentalism, kind of fundamentalists meeting member states, or whether it's this relationship that's still not clear about whether it's the Russian Orthodox Church or what those interests are, you know, whether they are business interests, political interests, or really so-called traditional values interests. Then the other grouping that we are yet to, it's the African traditionalists, you know, so basically there are ways to understand how these groups work globally, but I don't know if there has been that much investment in seeing the combination of the collusion of these various kind of anti-rights groupings that are growing on the continent. And so maybe this is the time for us to not only lament, but to imagine what moving forward with all of these processes that we have in place actually look like. So what do you have to say in closing?
Well, I think a couple of reflections in relation to this. I always think that in developing knowledge and understanding of these issues lies the basis for optimism. So the more we understand the situation, the more we are able to carry out situational analysis and try to create strategies around it, the more I think we have reasons for being optimistic, because I actually, I'm convinced of the mighty power of movements, communities, and populations that we serve. So even in what depresses us, which is that deep understanding of reality, lies, I think, the seed for optimism. I think that the next few years are going to bring significant challenges. I would class them under three main categories. I think the first one is the challenge of political regression in the midst of significant ideological debate concerning the use of gender theory to deconstruct and address violence and discrimination. Excuse me. And I think this challenge is ever so mighty, ever so much more daunting, because this strategy of destroying the use of theory of gender is supported by great powers in this world. The second challenge, I think, of what may be many, but the ones that I actually have identified quite strongly in my agenda, is the possibility of regression in the capacities and abilities of the movement. What do I mean by that? There's a lot of talk about shrinking civil society spaces, but I always like to use the expression of my dear friend Cynthia Rothschild, who said to me a couple of years ago, civil society spaces are not shrinking, they are being shrunk. They're being actively shrunk by the fact that funding is slowly being cut in the human rights pockets, by the fact that spaces are slowly being closed, by the fact that our colleagues in organizations are having to fight for every space that in very many ways have been taken for granted. And that includes regional and universal bodies, just like you have expressed very well. And finally, I think the third great challenge is the possibility for fragmentations within an agenda that up to now could be perceived as fairly, not homogeneous, but as energized from globality of the movement. And I think that we see significant risk for fragmentation in that agenda, in that we know that there are significant populations that are being left behind within the LGBT community because their problematics, their struggles are a lot more deeply connected to issues such as colonialism and religion and social mores, rather than accessing just certain institutionalities such as equal marriage and adoption and so on and so forth. So I think all of those challenges must be met with great energy. What gives me reason for optimism, as you know, we have evidence that change is possible within a generation. We've seen it happen in many contexts. So we know that, I've heard it said that there are two issues in which change is possible within a generation. One of them is the fight against tobacco, and the other one is LGTB issues. And I think that part of that will be the work of identifying key points of entry through strategic litigation as well, to make sure that systems are pushed to do the right thing. And again, hoping and doing our best to ensure that all circumstances are there in the best manner possible. So I have great hopes for this transformational work that is being done through strategic litigation all over the world. And of course, you have my support and the support of the mandate of the independent expert in its furtherance.
Thank you very much. I would like us to, just take questions and then we will answer and then wrap up. Are there any questions from the audience? We can continue the conversation. Stefano, anything? No?
Not yet. Feel free to raise your hands or write in the chat.
Or unmute yourself.
I will need to unmute, so they.
Okay.
I need some sign from people.
Yeah. All right. Yeah, I can't see anything from my end. So I think when it comes to, I mean, I don't always remember who said this, that one of the things, it's basically something along the lines of not making despair, look convincing, and that's what basically we're all trying to fight against, right? To remain hopeful in a context where there are so many kind of threats and challenges. And so sometimes it does feel like, okay, in other systems, what has made change possible is that at the very least you had a mechanisms that says, we are not here to mirror the prejudice, of states. We are not here, as puppets. Our job, we know what our job is. Our job is to hold states accountable for human rights violations. That's what we stand for, And right now, this kind of moment of conflict, it's about rebuilding confidence in the mechanism, that it can actually stand for the defense and protection of human rights, and that in the face of all of these threats, because the threats were vicious, threats around defunding, but basically threatening the commission with its own life. It's you will not survive. And some of the things that were quite hard, I think, to witness as parts of civil society, it's that the fragmentation that you talk about became a fragmentation of civil society. That here you come with this LGBT issue, and now you have threatened, a mechanism that exists to serve all of us. And here you are with a radical agenda, trying to push something that's maybe you care about, but it's not as important as the other issues that the commission is. So it's basically Operation Olympics, that one has to contend with. And we are seeing this not only at the African Commission, some of the practices there were about if other civil society organizations in a civil society space say, we don't really think that this is a human rights issue. And then you have people who hold the space saying, maybe let's vote on it, let the majority vote on the rights on the minority so that we can decide whether it is indeed a human rights space. So the fragmentation has been real. And when I look at what happened to the African Commission, it's been 5 years since the first attacks started, very visible attacks started against the commission. And what is also important is that these were not really attacks at the commission because of the work that it did by giving Carl's observer status. But it was an extremely convenient scapegoat because the decision to 2015, basically, what it does, that decision of 2015, of the African Union, is you have something that speaks to, it's the 2018 decision that speaks to the Carl issue, but at the very heart of it, it's about dismantling a mechanism, not as a retaliation for the work on SOGIE, but because SOGIE is an easy issue to coalesce, other people to mount a resistance or an attack, it then became the dominant narrative that the political, leaders or the state administrators, as other people call them, are the ones, they are upset because the human rights mechanisms have kind of gone rogue. But when you actually look at it and just analyze some of the conversations that were happening there, it was when Egypt really pushes for this decision, it's about retaliating for being taken to the General Assembly, by the African Union. But the narrative is so powerful that with progressive organizations, that's what we we're sort of known as the people who kind of broke the system, you know, by doing SOGIE advocacy at the African Commission. So that kind of fragmentation and also that kind of fear, because it also broke the movement, you know, because we've been through a 5-year kind of hiatus at the African Commission with people convening, but really not engaging the mechanism, you know, or the system because of this fear, you know, what would happen to the system? Can it respond? But more importantly, what is reasonable or sensible engagement when the mechanism itself can be forced to reverse its decisions? I see there are questions.
May I just help? So there are one question and one comment that are related to the issue that Sibongile you just highlighted, like the reaction of states and sort of like vis-a-vis civil society. So Berini Bogora is asking, it would be interested to know how the work of Victor's work, so the work of the independent expert, has been received by African states. And Susanna Fried is making a comment, an appreciation for the point that civil society space is shrinking, is not shrinking, but is being shrunk. And I would add that in so many ways, movements are expanding in themselves, but also in conversation with other movements. There are a couple of other questions, but they are not related to this point. So maybe.
Would you like me to answer?
Yes, please. Yeah, you can start, and then I can answer. I think the question from Christopher, which is kind of directed at me. Yeah.
Yeah, the reception of the work by African states, and I'm very thankful for that question because it's of course very rich. You may know that the creation of the mandate was extremely controversial, and that in the midst of that controversy, certain regional blocs manifested themselves pretty much uniformly against the creation of the mandate. The idea was, I believe, that the creation of the mandate was responsive to a dark agenda of promoting homosexuality and same-sex marriage. The African bloc at the UN was such blocs actually manifesting itself against the creation of the mandate. I'm very pleased that throughout the first 4 years of existence of the mandate, well, 3 years, now almost 4, I think that there has been significant work in trying to bring forward an evidence base that makes it very clear that, that we cannot turn a blind eye to using sexual orientation and gender identity as decoders of violence and discrimination. And that it would be tantamount to negligence from the states to actually do so. But also, in that context, I was delighted to have a country visit to Mozambique, a country in which I carried out a visit that I was very pleased about by the collaboration of the government and the civil society and my ability to establish interlocution and findings. And I have carried out a number of bilateral initiatives in relation to African states that I think led to the fact that when the mandate was renewed last year, there was not such a thing as bloc opposition to the continuity of the mandate in any region of the world, and that included Africa. And as of now, I sustain dialogue, bilateral dialogue of what I think is quality with a number of African states. And as you know, one of my first activities was dialogue with the African Commission and in this connection. So I'm very optimistic about the possibilities for dialogue. Now, I don't want to appear rosy-eyed in situations where we need to have great seriousness about our work. I am not often satisfied with the level of response to my individual communications from African states. And this is, of course, very much germane to issues of strategic litigation, because the individual communication mechanism before me can be seen as one of those that can be part of strategic litigation considerations. I'm not always satisfied by the level of response to my communications. That is a general finding. It's not only related to Africa. And of course, I would like to see a different type of reality when it comes to issues not limited, but relating to criminalization, conversion therapy, legal recognition of gender identity, and of course, gender-based violence and exclusion as such. So I have great hopes for my conversations with African states. And so far, I have never found a closed door when seeking to have it. It doesn't necessarily mean that as a result of entering that door, there would be immediate change.
A less well-known anecdote that may have contributed to you not encountering resistance from in the form of bloc opposition. In 2010, Egypt got the AU to adopt a resolution to basically engage as a bloc on SOGIE issues at the United Nations. What happened then is that this is what sort of gave birth to that first very ugly draft resolution that South Africa presented, because that was basically something that was coming from the African Union, led by Egypt, and now being taken to the UN, that this was the Africa kind of position as a bloc. But having started, by adopting a resolution so that if anyone changed their position at the United Nations, then it's basically an African Union member state that has kind of gone rogue. So to hold them at regional level first, so that they are not able to do other things. But then the Arab Spring happened, so that's how we ended up with that resolution. The question to me, it's about whether, in my analysis of what has been possible, that we are now left with Resolution 275, is whether I think violence would be an easy or an amenable kind of entry point. The answer is definitely yes. I do think that if we are going to start, we need to be able to start at kind of violence, kind of incrementally, because we already have the language. And so the bulk of the work, it's about state accountability to act with due diligence. So some of the cases that we are developing are cases where, because of the language around what's criminalized and what's not criminalized, and so there are people who like to say so homosexuality is criminalized. So basically, you criminal on sight. It's not because of a distinction between an act or a conduct, and a person. And this is obviously a subject of intense debate, because there are other people who feel like if your sexuality is criminalized, then your personhood is also criminalized. So there really is no distinction between criminalizing conduct and criminalizing a person. But when you look at the jurisprudence that has been developed across a kind of English-speaking Africa, where courts have been called upon, this has been a very important and very useful distinction, that the courts have actually made, to say that there is a crime, and the crime, it's what we will have to deal with. So the work that's going on around decriminalization, that's one aspect of that. But if we don't make this distinction very clear, it's that people whose rights are violated on the basis of SOGIE then don't avail themselves, to legal protections or seeking recourse because of this belief that the individuals are criminalized, kind of outlaw, and so perpetuates this idea of living on the margins of the law or outside of the scope of legal protection. And so one of the things that you talked about is like the dehumanization that actually begins to exist, in law, because people do not think that. So some of the cases that we are seeing have been of people who go to the police station because they have been attacked by a mob, and then they are the people who eventually kind of get charged, of an offense.
Right.
And so what was useful, I think, in Resolution 275, it was that you didn't have to necessarily identify, but if you wanted to, you could. But it was like SOGIE-based violence. It was whether it was real or imputed, So because people thought that you were gay, you got assaulted. So I think it becomes easier. So even for people who don't want to out themselves, to be able to say that I was violated and the state refused to act. So the due diligence, just a positive obligation to investigate, prosecute, and punish acts of violence. It's something that looks like it can be kind of doable in that kind of context, because if the mechanisms understand that there is an obligation to basically protect people from violence, they will be able to do that. What is interesting is that the African Commission has looked at about 2 cases on violence against women, and the other cases have really been before the regional economic courts like ECOWAS that have tried to do this. But there has been a struggle in getting violence. So whilst it may be an easy entry point, so one of the things is like they may get cruel, inhuman, and degrading treatment, which is fine. That is what it is. But when it comes to state obligation and also this understanding of violence as discrimination, they haven't been able to get that. So
Right.
Even most of these cases were cases of violence against women, but the way in which the understanding of state obligation to protect from violence has been quite kind of worrying, in that when it comes to slavery, they'll be able to get that there is a state obligation to protect people from slavery, but in the same case, not get that there is a state obligation to protect people from violence because they continue to see violence, as a private kind of act,
Right.
not attributable to the state.
Right.
So as an issue, I can see it as one of the kind of possible entry points in the mechanism, but whether maybe they will get the cruel, inhuman, and degrading treatment part of it, but still unclear that they will be able to get the discrimination, because even the African Commission that started in the first case against Egypt on women's rights, understanding violence as discrimination, has basically thrown its own jurisprudence under the bus in a subsequent case against Egypt, which says actually there is no discrimination that arises.
Yeah. That is precisely, I think that is a fantastic point. Also in relation to the way that cases get disaggregated into claims, right? And I think that this is one of the points that are fundamental, is when you have strategic litigation, and I very much appreciate what you say. Sometimes you don't get the particular outcomes that you were seeking for, but then there may be other cases in which the court actually goes in a different direction and provides other openings.
All right, I know that we have 2 minutes with you, so maybe we can begin to close. Over to you.
Thank you so much. I just want to thank you for the possibility of having this conversation. I know that in the participant list, I've seen some people that I know accompany the work of the mandate and support it very strongly. So I'm grateful to you and delighted that we were able to actually continue this conversation. I think that what I would like to leave you is with a reflection about the importance of the work that is being done to identify and to believe in the international machinery. One of the great determinants of this work will always be that it faces the shortcomings of being inserted into a political institutionality. That's just the reality of the particular setting in which we are inscribed. But as we have seen, the potential is enormous. And when we have the possibility of looking back, I already have a career that spans 25 years, so I'm going to age myself now. And when we look back and see the change that has been done through strategic litigation in the last 25 years, I think that it's very clear that it's a worthwhile endeavor. It's a long game, it's a risky game, it's a game of endurance, but it has extraordinary results. And of course, I commend you all for being the ones undertaking it. And I'd like to just repeat, you have the support of the mandate of the independent expert in your endeavors. So thank you so much for inviting me to the conversation.
So we heard you about the support, and you will be hearing from us about an amicus intervention in some of the cases that will be taking before the regional human rights systems to begin this work of investigating once more what is possible in terms of state accountability and standard setting work. So thank you very much for making yourself available, and we really appreciate your time and all the work that you do. So thank you everyone who made the time to be part of this webinar. Thank you very much and goodbye.
Bye.
Bye.